Hi, I'm Barbara Lynn. I'm a federal judge in Dallas, Texas, and prior to that, I was a trial lawyer. I want to give you a few tips about being persuasive to a judge, either in a hearing or a trial. First of all, I want to talk about demonstratives. One thing that I have learned on the bench is that you need to be very careful about your exhibits. You will find that a number of judges that you will try your cases before, probably most of the judges, will be middle-aged, and some of the exhibits that may be perfectly visible to you may not be visible to the judge. I'm not being facetious about that. It's very important that the judge have copies of your demonstratives that are legible. And sometimes it's not the best way to put them on overheads, but rather to give the judge a copy and allow the judge to follow along. It's also very important that the judge have copies of anything that you want to have the judge have ready reference to. For example, in a very complicated file, to have the judge spend a lot of time reaching back into the file to find documents that may have been filed quite some time ago is not the best way to be persuasive. It's always advisable to have courtesy copies to hand up to the judge. Sometimes an outline of your argument can be very persuasive. I would suggest that you check with any sources that are available to find out what the judge's particular preferences might be. For example, the judge might want to have duplicate copies of any documents that have been filed handed up at the time of the argument. The judge might like to have highlighted copies. The judge might want to have you give the judge a little preview of what's going to be presented. And of course, there might be time requirements that might not be recorded anywhere. Any information that you can obtain from any sources, whether written or unwritten, whether lore or reality, could be very helpful to you. Now, in addition to that, I want to talk for just a couple of minutes about particular ways of treating the judge. By definition, when you are appearing before a judge, either in a hearing or a trial, obviously it goes without saying that the person you need to persuade is the judge. So therefore, if the judge has a question, that should be a matter that should be of interest to you. It's usually not appropriate to say to the judge, well, I'll get to that later, or treat the judge's interest as something of subordinate interest to you. Because if the judge is going to be making a decision on your matter, if the judge is interested in the subject, you need to at least appear to be interested in it as well. Now, it may be that the judge is on the wrong path, and that particular area is not something that is critical to the issue at hand. But the best way to treat that is to work the judge's interest into your argument, letting the judge know why that may or may not be a significant matter. But by definition, you need to pay attention to what the judge is interested in, because the judge is going to be making a decision on your matter. Similarly, I learned from being on the bench that judges don't particularly like to be interrupted. That's something that seems to come with the territory. So let the judge get his or her question out, and then again, try to answer it directly. There may be particular issues that the judge has a focus on that you are not prepared on. There's absolutely nothing wrong with suggesting to the judge that you don't know the answer to that question, or you're not prepared on that topic, and ask the judge for permission to submit something after the argument. Judges appreciate candor. You can bluff your way just so far. If you don't know, the judge will appreciate it if you say that you don't know. The final thing that I want to say about being persuasive to a judge is that your credibility is at issue all the time. If the judge feels that you can be trusted, then you'll go a long way in being persuasive to the court. There's nothing wrong with acknowledging weaknesses in your case. In fact, I find that that is the best way that lawyers can be persuasive to me. They'll tell me what they know, they'll tell me what they don't know, and then I know that I can rely on them. So I think with these few tips, you'll be more persuasive when the judge is going to be deciding your matter.